very much to all the people who've given the presentations. I did know quite a lot about TTIP because I've been fighting for a few years against it, but this has given me a full comprehensive. I'm interested in particular in the NHS, and I'm a member of Keep Our NHS Public, and I'm aware of how our government, who are undemocratic by the way, are trying to murder the NHS, and they're doing their damnedest. We have Simon Stevens, who's head of NHS England, with his 5-year forward plan. He worked in the US for many years in the healthcare system, and he's determined to impose that model in this country. And I think people don't realise what's going on and how stealth steals. Apparently the World Health Organization said that our NHS can't be seen as a national health service anymore because 37% of it has already been privatised, and that's done by the back door. I mean, most people now, when they go to their GP or to hospital, they're being offered a choice, and they see that as democratic, when actually it's the NHS, and then you have 3 private providers. And a lot of people, if they're seen earlier, think that's great and that's wonderful. But my take on that, if you're chronically ill or you're terminal, they have to see you anyway. But people aren't aware that money is being hemorrhaged out of the NHS through the back door by our government. And with the TTIP, for me, I believe our government wouldn't dispute or counter any private company because they all have vested interests and they're quite happy for this model. So I think people need to realise what's happening here, and it's just wonderful to hear everything you've said. But the reason I concentrate on the NHS is from the tiniest baby being born now to the eldest individual dying, at any time we can all require intensive healthcare through accident, injury, terminal illness, chronic illness. It's the one thing we all need. So when people say, why is it the top of your agenda? It should always be at the top of the agenda. And I just see it as TTIP is the final nail in the coffin of privatising the globe. They want about 5 or 6 corporations sitting there like Monsanto, like Carillion, Land O'Rourke, G4S, who do security, or murdering, terrorising children in Palestine using cattle prods, in South Africa on prisoners, sitting on people who are being removed from this country and actually killing them and getting away with that. So I think people need to wake up, because if we walk into TTIP, there's no way out, and we will be beholden to the private companies, who I refer to as the feral elite, for time immemorial. So we need to wake up and fight for the NHS, and then everything else will follow. But thanks very much anyway.
I'll be cheeky and tack on an extra little question from your statement as well, which is, to what extent are TTIP NHS concerns really just a result of the way that we've chosen to structure the NHS? If we had a different system,
I think if the UK had a vertically integrated public system with a lot of in-house provision, and should we talk about a really public system without a provider-purchaser split, or without an internal market for healthcare, then yes, TTIP might not have been applicable. So long as small proportions, even small features of market principles, and even small proportions of private provision suffice for the purposes of subjecting the NHS to TTIP, because I think the public services which are the most susceptible to the implementation of the TTIP principles are the ones that whereby there is a mixture, there is an amalgamation of public and private sector. So long as public and private coexist, TTIP is applicable. So should there be an insulated public system, I don't think that the risk would be that high. But especially because of the NHS and Social Care Act of 2012, I think the NHS is more vulnerable to TTIP. But I think I'm not here to discuss on this. And I'm not a UK citizen, I come from Greece, so I'm not very familiar with all this detail. I think there has been an official declaration by the UK government that they are willing to discuss the exclusion of the NHS. I don't know how this will take effect, and I don't know the way in which it will be exempted. It's very important that the wording is of immense importance, so it may be something rhetorically perfect, but in substance void.
Yes.
So I really hope that there will be some progress in this regard.
Not regarding our government, there won't. And the NHS is not
I'm not here to talk about the government, I'm just mentioning that there is some progress.
I don't think there will be, and the NHS is not sick. The feral elite who are destroying it are, quote me.
Even if we get a carve-out for the NHS, you've got no control over what happens next, because that then goes into dispute resolution procedures over which we have no control. And so I would it be a pretty false sense of security to think that a carve-out for the NHS would be a solution to the problem. It's only the start of the problem.
I would like to ask a question about the gender aspect that was mentioned, which was really, really interesting and I had no clue. As you said, your argument was that in the way it's mentioned, it's more likely that it will empower investors rather than women, for example. My question would be, apart from being useless or like toothless, would it actually be used by investors to act, in your opinion, to actually undermine protections? I mean, apart from the general picture, which is women tend to lose out more from trade liberalization, would you think that it could be used to target, for example, things that states might enact to promote gender equality that might look like discrimination, but in reality, so would you think that there is this potential, would you think it would just be toothless? So my question is it toothless or could it potentially actually be harmful?
I mean, I think that's a very good question. I don't know what the answer to that is because and I feel like the creativity with which investor arguments are being made as we progress forward are increasing considerably. So would there be a way for someone to figure out to challenge a particular measure on the basis of gender? I think it's entirely possible. I can't off the top of my head think of something right this moment. But I think it's definitely possible. The problem is once you introduce these things, it is another ground for which you can use to challenge a measure.
Just leading on a bit from the NHS discussion, I just wanted to point out that there's going to be collateral effects of TTIP no matter the carve-out in terms of costs to the NHS through increased intellectual property provisions driving up prices of medicines, for example. And not only can that lead to a drive up of costs, but that will be protected under ISDS. So there'll be a cost to the NHS under TTIP, even if directly issues of NHS are carved out from ISDS. It's something worth keeping in mind. I just had a follow-up question, which is, I just wanted to ask Mr. Howse, what do you really think about this new proposal from the Permanent Court from the European Commission? So you gave a bit of you gave the balanced approach. Okay, you know, they're at least coming out with some sort of reaction to the intense amount of critique on ISDS, but the fact is they're not addressing all of the critique. You have to agree to that. And then even so, the critique that they are addressing is the low-hanging fruit. Like there are a lot of objections to ISDS. Now, you know yourself, having spent a lot of time looking at the WTO appellate panel, the quality of judgments, the quality of the process, etc., there's just such a massive gap that, you know, coming up with a couple of changes is not really going to make a hell of a lot of difference overall. And I also wanted to ask you on that, the fundamental difference of a state-to-state dispute settlement system and an investor-state dispute settlement system. And within that context, the well-known trajectory of tribunals to extensively interpret the provisions of the agreement, which to a certain extent could have been the case with the WTO, some WTO dispute and settlement bodies, but has been wound back. So I just wondering.
Just before you get a chance, I know there's another related question which we'll tackle
my
as well.
question was going to be very much along these lines, but if I could just ask a tiny sort of extra twin to it, because and I'm also a little bit worried because I was going to say exactly the same thing from the panel in the next session, so this is all going wrong. But I think I do need to take issue with you quite strongly in the suggestion that the European Commission has listened to and responded to civil society's concerns on the ISDS/ICS, which I do think is seriously wrong. And as someone who's been absolutely profoundly engaged in that process from the beginning and met Cecilia Malmström once the consultation had taken place, we as civil society were not engaged with the issue of ISDS in the same way as the international legal academic community have been. I've written on that myself, so I know all the problems in terms of the inconsistency of the judgments down the years from NAFTA to Argentina to Czech Republic, etc., etc. For civil society, it was precisely the principle that we would be elevating foreign investors to the same status as the nation state, which is why 97+% of the respondents to the European Commission consultation on ISDS did not say we had a problem with the lack of an appellate mechanism, did not say we had a problem with the judges all being bent, did not say we had a problem with it being untransparent. We said we have a problem with it tout court, absolutely in all of its entirety. And the European Commission said, we don't care. And when I said this to Cecilia Malmström, I said to her, you know, you've responded to us with these tiny cosmetic changes which have absolutely nothing to do with our concerns. She said, I do not take my mandate from the European people. And so I really think it's important when you're playing this out, absolutely everybody can have their own opinions about the actual changes, as to how substantial they are or not. But it's absolutely important to say that she did not respond to the European Civil Society at all. She kicked us in the teeth.
Oh, no, we're just going to get into the sorry.
So, you know, I think that I can answer both these questions at once, which is I would be the last person to deny the strength of what I would call the more general critique of investor-state dispute settlement and investor protection, which is essentially, you know, why should foreign investors have a right to recourse to a special legal system which domestic economic actors don't, and especially why should they have that recourse in a context like TTIP where both the negotiating partners have well-developed legal systems and protections for extensive protections for the rule of law, and I think that's a powerful case against ISDS as such. So you're quite right to say that in that respect, the Commission has not responded to the critique. But I do also believe that especially some civil society groups in attacking ISDS have not simply made that point of principle, and here we may need to disagree with respect. I think they have often invoked a series of decisions by tribunals that they have characterized as illegitimately intrusive in domestic sovereignty, and also the possibility to challenge successfully, regulations that no one would have believed at first could have been challenged in this way. And so, while it's true that the point of principle is a strong one, and that the Commission has decided to simply reject that view of principle against ISDS, it's not true that those espousing that view of principle have not also been extensively arguing and presenting the actual face of ISDS in terms of the outputs of these arbitral tribunals. So again, I could point you to specific papers of specific advocacy groups where both the point of principle and this other attack have been very closely linked. And I think they are linked also in the public perception. But so I agree with you in part, and I think we differ in part on that score. Certainly if you take the point of principle, why should there be a transnational level of dispute settlement at all in these matters? Then you will view the court system as cosmetic. If you think that there are arguments for transnational dispute settlement in this context, then you may not think that the changes are cosmetic. As a public international lawyer, it seems to me that there are some forms of abusive state conduct, whether towards individuals or towards legal persons, corporations, that ought to engage international responsibility. That's a different perspective than yours, but it's nevertheless a perspective that would suggest that there's some legitimacy to the idea that where a government is acting towards nationals of another community, another state, in abusive or improper ways, that should engage the international responsibility of that other country. And so actually, investor-state dispute settlement may be used in some cases strategically by corporations, and we can argue how much the TTIP provisions close the door to abusive or opportunistic use of it, such as the Philip Morris case. In general, these norms of fair and equitable treatment come out of a tradition of customary international law that concern the proper treatment of aliens. Now, I don't agree with the transformation of that through a specific group of individuals settling these cases who have pecuniary incentives to accept jurisdiction, because if they accept jurisdiction, they have money deciding the merits. I don't agree with a lot of that expansionism, but I do think that if they get the court system right, and particularly the way in which arbitrators, or in this case tribunal members, are remunerated and appointed, then some of these perverse incentives to take expansionary views of very basic norms that have a long tradition in customary international law may indeed be countered. I would also say, if you look at Donald Trump and other phenomena in the U.S. political landscape, you can say, okay, there's rule of law in the U.S. and there's rule of law in the EU. If you look at Hungary and Poland and so on, but you can see that even in a quote unquote advanced democratic societies, there is some possibility of pushback. And while it might seem arbitrary that investors would have special protections against that pushback, and that goes to the point of principle, which I respect very much, there is also an argument that every way in which the rule of law can push back against some of these kinds of dark movements to undo the rule of law, whether it's international or transnational courts or tribunals, whether it's the European Court of Human Rights or the European Court of Justice, perhaps we need them all as bulwarks against that pushback or against some of the darkness that's emerging in the political horizon, even within these countries that we know as kind of the landmark quote unquote liberal democracies, at least in theory.
Just as a follow-up. In thinking of the WTO example, do you think that the court would make a difference?
Yes, and in fact, it's from the WTO experience that once you went from quote unquote trade experts as the people deciding, who came out of a community that has a basic liberalization bias, and to an appellate court where generalists of international law dominated, you really noticed a difference towards a much more balanced view and much more sensitivity to domestic regulation, whether environmental regulation in the shrimp turtle case or to animal welfare in the seal products case. It's really kind of night and day. And this is what I emphasize to people who attack the court from the other perspective, that this is a matter of public law decision making, and that's where I think there is a good normative basis for the point of principle. It's essentially a public law matter to determine what is abuse of state conduct towards an economic actor. It has nothing to do with commercial arbitration. It should have nothing to do with people in corporate law firm environments. It's a matter for decision by persons trained in administrative law, constitutional law, and public international law. And that shift in perspective, I think, from the arbitration model to the judicial model, if the appointments process is conducted properly and the persons appointed have the character of public law judges, not those involved in this world of commercial arbitration corporate law firms, I think that should make a real difference, a positive difference. But I respect alternative views as well.
Okay, I'd just like to bring up about the collective bargaining and the way it's going in this country. At the moment, I work under collective bargaining for the national construction and the engineering industry, and we're under unprecedented attack by American companies and by European companies who are exploiting the posted workers directives. The companies, the way it's been orchestrated now is an American company will be the principal contractor who then subcontracts to Western European countries. Now their rates of pay are less than half ours. So when we go to apply for a job, they don't want to employ a British worker, they want to employ the posted workers. So the Americans and the big European multinationals all employ the cheaper European worker. So we brought this up to change the posted working directives, because when it was all signed back in '96, the countries that signed that were all working basically under the same economic model. So nobody was going to undermine anybody. Since then, we've had more member states come in. Now this is being abused, so we tried to get the directive changed. They put a yellow card up to us in March. There was 9 Central and Eastern Bloc countries said no, because you will place us at a disadvantage, because they won't want to employ European labour in Britain if they've got to pay the same as your collective bargaining. Now, my concerns are, if TTIP gets put in place, would the lower rates of pay, because they pay our minimum wage, which isn't against the law, would that lock in the minimum rates of pay, and would that be the end of our collective bargaining? Because none of these multinationals, especially the American firms, do not want to pay our national rates of pay.
Okay, that's a tough question. Well, I think the problem with the posted workers, there are a number of issues there. I think the problem with the posted workers directive, I think, is that we are peculiarly vulnerable in this country to the posted workers directive and the importation through that of cheap labour, because of our highly deregulated labour law arrangements. So in a sense, all employers are required to do is to bring workers in, is to meet the
minimum
requirements of the minimum wage.
Yeah.
Unlike in other countries where you've got very highly regulated collective bargaining arrangements, which have universal application, they've got to meet the rate for the job, and in a sense, as set down in the collective agreement. So in a sense, we are penalised because, in a sense, we are, or at least we're the victims of our own misfortune, in the sense that we have a deregulated labour so-called market because we're all treated like cattle. We refer to the labour market. So in a sense, because we have a deregulated labour market, we're exposed to these particular problems. But my issue about TTIP, in a sense, it will reinforce these problems because it will lead to a deregulation of these collective bargaining arrangements throughout the European Union. And I think, I'll give you an example why I feel so confident about this, is that in the 1960s, 50s and 60s, when American capital started coming into the United Kingdom. And big American companies like Ford's, who settled in Dagenham, for example, they came here and they said, well, we don't want to be part of these sector-wide industry, joint industrial councils. We want to do in Dagenham what we do in Detroit. Well, nobody does anything in Detroit now, but we want to do in Dagenham what we do in Detroit, which is we will have our own collective bargaining arrangements with our own unions if we choose to do that. And so in a sense, as American capital began to withdraw from these multi-employer sector-wide agreements, the whole system began to collapse. And it was just given that added push by Thatcher in 1980. So we ended up adopting an American-style collective bargaining system, which saw our collective bargaining coverage decline from 82% in 1978 to what is about 20% today. And that is a threat. In a sense, you will see the same thing. It'll be like a game of dominoes. In a sense, it'll be one after another. They'll just all begin to fall over the course of a generation. And if TTIP were to be implemented in its present, well, even as the EU demands, the Labour chapter as the EU demands, what you will see is the evisceration of collective bargaining structures throughout the European Union and the reintroduction of a different kind of collective bargaining, which is based on the enterprise, as in the United States, and it will lead inevitably to American-style levels of collective bargaining coverage, which is about, what, between 6 and 10% on a good day. Now that will then lead to an exaggeration of the problem which you have just
It's a drive to
we're in this
lower all our
vicious
wages.
cycle of decline, and this will encourage that process. But while I've got the floor, I would just take issue with the ISDS stuff. I don't think is, in a sense, to change the arbitrator, to have public lawyers or administrative lawyers, I don't think that's the real answer. Because, in a sense, American public lawyers are coming to these processes with a different cultural baggage than would, say, a European public lawyer. I'll just give you this contrast. So let's say we have somebody from Italy with a background in Italian public law. The Italian constitution begins with these words: Italy is a republic based on labor. That's a very different starting point from the US Constitution and the values which the US Constitution or the lawyer trained in the US Constitution brings to these processes. So I think, what we've got here, we've got a real clash in the sense which in ISDS, you can see the ISDS as being a forum in which you see this ideological clash between social Europe and liberal America. And the question is, which of these values is going to prevail? And I'll tell you what is going to be through that process.
I think you were making the point I was going to make. Why are investors, this special group that can sue governments? What about workers' rights? It's so anti-democratic that we've got working rights in Britain have just gone, they've got less and less and less. And we are getting more privilege to investors. That is so anti-democratic, really, and it's been done behind closed doors without people fully realising the implications. Our NHS is being undermined, and everything else is, and there is so little discussion about it in this country. If the normal people in this country knew what was going on, and we're not being told,
Well, you're right in a sense, but they want you to vote Remain.
Oh,
to protect the rights that you don't have.
Yeah, I think Boris Johnson and Trump could, do TTIP between them in half an hour.
I've got a couple of points to make. Firstly, thanks to the panel for your time and views. I don't necessarily agree with them all strongly. I apologise to that gentleman for my involuntary reaction. I laughed quite manically at Mr. Howse on his phone, sorry. I was thinking about a joke about battery life of iPhones, apologies for that. I've been under the care of the NHS for the last 2 months for manic episodes. And I'm getting discharged today, so cheers to that. So therefore, I agree with this lady over here about keeping the NHS public. I vehemently believe in that. I take issue with the boring remark about procurement, Greg, Mr. Chair.
I'm sorry, I didn't hear you. What did you say?
I vehemently believe that the NHS should be kept public. I completely disagree that any private investments or any further, let's say, private investment should be pumped into it. I'm very concerned that TTIP would tip us over the edge into private sector health insurance and all the rest of that nonsense. American style, right? It should be free at the point of entry, it should be free at the point of exit, and it should be free in the middle. Well, the question I have particularly was with regards to procurement, because I'm a civil servant who, for the past decade, has worked in procurement, with a bit of time in commercial law in between. The ceiling of 49%, is that definitely going to go under TTIP?
I have no idea. I'm just, it was just
I missed age, I wasn't sure because...
No, it was just a speculation.
Because currently it's 49% of revenue generation from private patients. That's the ceiling. But that could theoretically go.
An investor might consider that it is very high, and that it must be lower, or it must be entirely disappear. It's only a scenario. It's only a case study. It's not that it will definitely happen. So an investor might wish to have more private patients in as an NHS Foundation trust. So I'm just contemplating, and I'm just speculating that an investor might consider this as a quantitative restriction on market access, and as such it could be a violation of the TTIP market access obligations. I just mentioned it as an example, merely as an example. But I mean, if we are dealing with a very aggressive line of investor claims, then they could pick up on anything that could is in favor of the public character of the NHS. But I guess that attacking this ceiling would mean the marginalization of public patients.
Sure. But and the increased profits of corporations, right?
Sorry, you had a question.
It's just an organisation, it's not a restriction on the poor. I think if people were born in poverty, there won't be anybody else, but if health and education, everything's going to be privatised. I worked in the NHS for over 40 years and also in the American system. And since Thatcher's, and it seems to have gone down, it was really good.
Sorry to get back to, I just didn't quite finish my question before. What I wanted to point out essentially is if the ISDS could be, if perhaps we lost an opportunity in terms of strategy on the to literally sink it, I think the ISDS on this particular issue we were talking about the principle we all seem to be agreeing on more or less of why particularly why are these I just wanted to ask you if you give an insight from the European Parliament. If there was more of an issue made of this, could that have been the point that sunk TTIP more politically rather than having a tactical debate? Politically, could the ISDS being in and the determination of the European Commission to leave it in, to fiddle around the edge, could this be done?
Can I just add to that question? It's the same thing. How is it consistent with obligation to promote and respect the rule of law in the EU Treaty to have a separate private process for big corporations?
Well, my personal view is that public debate SDS for the usual is still enough in TTIP and CETA, which I would be concerned of, even without ISDS. ISDS is a powerful tool to enforce it, but regulatory cooperation, where basically a lot of lawmaking, dialogue is being made without public scrutiny, all these kind of things are also very subtle. We have introduced elements of that, which which was the UK demand, for example, better regulation, where you also would have certain bureaucrats, for example, assessing legislation in terms of whether the old terminology was whether it's purpose fit or it's too bureaucratic. And there has been a tendency now, for example, to say, well, if employers have to measure working time, it's too bureaucratic because it produces compliance costs, which then, for example, may undermine minimum wage legislation because people are being paid minimum wage work much more in reality than we pay. So there are a lot of things even apart from that. But I think ICS is a powerful debate, and on ICS, I think that the main problem remains because, first of all, these corporations, I mean, this whole system starts with a discrimination. Domestic corporations cannot sidestep international courts. And I think I would be much less worried when we have, for example, normal court system. And a company that is really concerned that it's not treated in a fair way would then have to go to the national courts, and in the end there would be some public tribunal based on the experience, let's say something comparable to the ECJ, grounded in European constitutional law, where they might also bring their case to. I would have no trouble with that. But still, even if we reform ICS, in my view, we still have the problem, to my knowledge, the lawyers, for example, or the judges will be temporary, so they will not be employed by a proper court where they receive their money from, so there are still kind of incentives to have as many cases as possible there and things like that. And this is why my basic trouble remains, but we should not only focus on ICS, many more things to focus on, but I think this is one of the most important.
Can I respond very briefly on the compensation arrangements? These have not yet been completely solved, either for CETA or even less for TTIP. And I really agree with you. My preference would be for a compensation model that is much more focused on a salary, where the judges would be contracted for a minimum 4-year and ideally longer period, and would be paid a salary, plus perhaps certain additional amounts, but capped very low. And the argument against this is that only somehow that the really excellent people will only do this work for huge amounts of money. And I think that's rubbish. I mean, I don't see why someone who's motivated in a domestic law system to be a public law judge for a reasonable professional salary wouldn't be motivated to be an international judge. And you can make it, let's say, a half-time appointment and allow them to continue work that it doesn't involve conflict of interest, such as a university appointment, for instance. I think you can sort out the compensation issue. But I just wanted to say something about the response to the court in the U.S., because this relates to the extent to which, it will be a deal breaker for TTIP. The response so far by the kind of middle to senior level officials in the United States is very negative. They really want to keep the old system of arbitration. So my sense is that one possible outcome, if the other stumbling blocks to TTIP can be resolved, is that you will have TTIP, but no investor-state dispute settlement. And not because necessarily the Commission is now listening to the people who object to it on principle, but because what the Commission has done, and here I will defend it, is that they've drawn a line in the sand. But Malmstrom, by saying that the existing system is characterized by a fundamental lack of trust, is not going to be able to go to your parliament and say, we gave in to the United States and we're putting in TTIP, a system that I have admitted publicly is characterized by a fundamental lack of trust. So she's tied her hands to this extent. that either the U.S. will accept something like the court proposal at TTIP, which it doesn't seem inclined to, or most of the officials involved seem very opposed to, or maybe TTIP will go ahead without ISDS. And so, one wants to worry about placing too much emphasis in opposing TTIP on ISDS, because there's a very real possibility that that will be the fallback position of both the United States and the Commission, and then all the advocates in favor of TTIP will say, oh, we've listened to the complaints about ISDS, we've accepted the point of principle, it's not there, so TTIP is fine. So I think you're quite right to emphasize that there has to be scrutiny of many aspects of TTIP, but it's not necessarily the case that ISDS is the one that one would have the ultimate concern about in terms of protecting legitimate domestic regulatory interests.
It really follows on from that. My name's Carolyn Jones from the Institute of Employment Rights. It really follows on from that although the trade union movement was slow to respond in the UK to TTIP, when it did respond, its response was to reject it rather than try and tinker with bits of it. What we certainly didn't want to see was unions breaking off to say things like, if the NHS is excluded, then it will be okay, because it won't be okay. Similarly, as you say, if ISDS is taken out, then it will be okay. No, it won't be okay. So the end result was that there was agreement across the British trade union movement that the response should be to reject TTIP in its whole. And part of that is because of the enforcement, because we can write all the sentences that we want to say NHS should not be included, but there will be a ways around it, as people have said. It's the same in the UK. There are many rights that are written down for UK workers, but they're not enforced. They're not enforced because there isn't a will. They're not enforced because access to tribunals to enforce those rights have been removed. And it will be the same with those. The only way of enforcing rights is through, as Keith has said, through trade unions being strong and collective bargaining, overseeing terms and conditions of employment. One of the problems with the ISDS, getting back to that, is trade unions have no standing. So the very people who represent the interests and the rights and the terms and conditions of workers who are going to be affected by this don't even have the right to approach the ISDS. So that, John Hendy always says, well, you might go to a tribunal here, or to a court, or to the European Court of Justice, or to the European Court of Human Rights. You might win, you might lose, but at least you've got an opportunity to put forward some kind of argument in favour of workers' rights. Under ISDS, you don't even have that right. You can't win the case if you're not in the court. And therefore, the idea that it's only the investors who have a standing to take up the issues is rejected, which takes us back to TTIP ought to be rejected as opposed to tinkered with, whether it be the NHS or whether it be the ISDS.
I would just, there is intermediate status of a sort in the court proposal. So there would be a possibility for trade unions and other organizations to intervene in that capacity. It's of course a limited form of standing, but it does exist.
Can I just make a comment? It strikes me that the creation, this proposal to create permanent investment court under the TTIP, even though it's considered as a lesser of two evils when we look at ISDS and obviously propose the permanent court, it strikes me that this is such a neo-colonial, neo-imperial tactic, because the rest of the world will still have to deal with possibly unreformed ISDS. So the countries which are less powerful and which have less opportunities to engage in this whole transformation through their civil society groups, etc., Argentina, Ukraine, Zimbabwe, they won't be able to do anything like that. So we will have this system of where there is tiered system where the United States and the EU suddenly say, well, we don't want to be exposed to investor claims, let's do something about it and create a better mechanism whereby we will be slightly more shielded from those investor claims. But again, the governments of Zimbabwe, Argentina and Ukraine won't be able to do that, and that's a classic neo-colonial and neo-empirical technique, this tactic when the powerful states, they just simply withdraw from the rules when they realize that those rules don't quite suit them.
In defense of the Commission, and I find myself in a very strange position of defending the Commission, there is a clause that foresees the multilateralization of the investment court, and that's not a mere window dressing. The Commission is pursuing a separate, simultaneous track of discussing with other partners how one could create a multilateral court, which then these regional courts would be kind of folded into. And I've been to a number of meetings and discussions involving people in the Commission and many other stakeholders about that. And so it's a very serious effort. And it's not insignificant that the first time the court proposal was ever incorporated in a treaty, it was in the EU-Vietnam Treaty. So I take your concern, and I would not like it to work out the way that you suggest as a neo-colonial intervention, but rather I think the multilateral route is promising. It's also promising for addressing some of the real legitimacy concerns that have been mentioned here, such as the fact that it's only investors that can sue. What about having other actors being able to make claims related to human rights, labor rights, environment in investment disputes? And all of these ideas are on the table in terms of getting the multilateral track going. And so, I'm cautiously hopeful, but TTIP I think needs to be evaluated in terms of everything in it, and not especially, as I say, the ISDS. Yeah.
Yeah, we've got time, I think, for just two brief questions. The two gentlemen here who've been trying for a while. Okay, first.
Okay, I just a clarification regarding what you mentioned about the struggle between the multilateral agreements and the bilateral agreement. What's happening now? Has it got any relations with what's happening in the South China Sea?
Has what got any?
Yeah, what's happening in the South China Sea? We all understand what's happening there.
With the TPP, well, it's only just, it's further advanced than the TTIP, but so far as I'm aware, there's a lot of anxiety in Australia about it, but there's as far as I'm aware, it's not operating fully. Yes, there's no evidence as to what its impact will be. So what I'm saying is that we can look at this recently concluded agreement, and if you are optimistic, you could take quite an optimistic view that it will have a benign, perhaps desirable effect. But we're 20 years before we can make any sensible judgment, I think, about that. But let me just come back on this other point about TTIP. It's the issue of sovereignty which comes up a lot. But the issue of sovereignty is not just about ISDS and dispute resolution. The issue of sovereignty is about the impact that the agreement will have on chilling domestic policy, which might be implemented to give effect to the wishes of the people at an election. And one example, which is close to my heart, is the proposals that we re-examine our collective bargaining structures and go back to the type of arrangements that were destroyed in 1980 and which operate successfully in much of the rest of the European Union. Now, we will now give our government, of whichever party, a brilliant reason for not doing it. That is because of the pressure of TTIP and the pressure from investors and the pressure on us to be productive and efficient and competitive in this new market. So it says that too. The danger to sovereignty is not just a direct impact through things like ISDS, it's the indirect, insidious restrictions which will emerge as a result of this.